Let's talk about the Indiana inheritance tax and the federal death tax. Indiana has had an inheritance tax for a number of years and has made a few adjustments over the years, increasing the exemptions for children, but not for very many other people. A year ago, Indiana made a major expansion of the exemption for children, moving from a $100,000 exemption to $250,000. The legislature then decided to phase the inheritance tax out over a 10-year period. When they met this year and the state's economic condition had improved, the legislature then repealed Indiana's inheritance tax, retroactive for any person who died after January 1, 2013. The impact has been fairly significant. Most states had the calculation and determination of the inheritance tax as a major guidepost in the process to closing out the estate. As a result of the repeal of the inheritance tax, that guidepost has vanished, and now Indiana lawyers are paying attention to protect the creditors of estates, most especially the governmental creditors, while handling everything in a timely manner for the families of the decedent. At about the same time, the federal government was changing the federal death tax, or the federal estate tax as it's oftentimes known. You may remember that last December, Congress looked at the fiscal cliff as being a critical point in determining taxes, because the tax was going to go back to a $1 million exemption. Congress finally approved a $5 million exemption, adjusted for inflation, which makes it about $5.25 million per person for bequests left to family members or other persons other than charities, churches, and universities. That means that a husband and wife can now leave about $10.5 million to their children and other family members without there being a federal tax. So death taxes are no longer an event for an Indiana resident unless you're within about the top 1.5% of taxpayers.